Who do you think is the biggest employer diri sa atuang nasod? The biggest employer. Sa pinaka dako nga employer sa atuang nasod karon. What company do you think or what entity do you think is the biggest employer in the country today? Any idea? Any idea, class? Pinaka biggest employer. Yes, sa Pilipinas. Biggest employer diri, BDA. Pila ka mo empleyado nila dito. Galing ha? Talagang magaling ha? Talagang na-research mo yan ha? Ano pa? Sino pa ang may alam na biggest employer dito sa Pilipinas? Aside sa BDO. Ha? SM? SM? How many employers kaya sila doon? PLDT, how many employers ka? 18,000. Sa BDO, ilan ito? 33,000 to. Bigger ang BDO. 38,000 sa BDO. Sa PLDT, 18,000 lang. Oh. Napamay mas dako sa BDO. What about San Miguel? San Miguel Corporation. Pila ka empleyado ka dira? Oo. Google more. Google pa more. Try Google ninyo kan. SM, pila ka dako? Pila yung empleyado? Ha? 89,000 ang SM? Oh, binugo no. Kisa tong million. Kisa tong ingon million. Kisa tong ingon million. Nakuha na yung empleyaduha, oy. Tamano, million. Kisa na nga employer ni mo Tamano. Kisa dito. Kisa dito. Okay. Try search. Search niyo pila ka buok empleyado niya. Search niyo. Okay. Andam na mo. Kuhanin niyo ha. Search niyo. Dali. Pila ka buok empleyado. Philippine government. Search. Pila ka buok empleyado. Dali. Philippine government. Do you have the figures? Philippine government. Philippine government. Million? O, totality na siya. Totality na siya sa tanan-tanan ng employer. Yeah. But, kung sa Philippine government lang, apil naman muna mga ubang employers dira sa 41 point something million. Pero Philippine government lang, it's about 1.3 something million. That was in year 2010 lang. I don't know karon pila na kabok empleyado ang Philippine government. So you see my point here? The biggest employer is the Philippine government. So that's why we have to really have to be so strict on the Philippine employees, government employees, so that basic specific laws are on them related to the Philippine employees, Philippine government employees, strictly para sa ilahan lang yun siya. Ano mga balaod, specifically sa criminal law, no? Revised Penal Code. That's why it is being dedicated kaning Title 7, kaning crimes committed by public officers. Public officers consist sa mga pinakababa diha, ang janitor up to the President of the Philippines, including senators, tanan mga employees na sa gobyerno. So Article 203, who are public officers? For the purpose of applying the provisions of these and the preceding titles of this book, any person who by direct provision of the law, popular election, or appointment by competent authority shall take part in the performance of public functions in the government of the Philippine Islands, or shall perform in said government or in any of its branches public duties as an employee, agent, or subordinate official of any rank or class shall be deemed to be a public officer. So, any rank o class ang tawag sa ila public officer. Public officer or employees. Definition is quite comprehensive, embracing as it does every public servant from the highest to the lowest. For the purposes of the Penal Code, it obliterates the standard distinction in the law of public officers between officer and employee. So requisite to be a public officer, one must be taking part in the performance of public functions in the government or performing in said government or in any of its branches public duties as an employee, agent, or subordinate official of any rank or class. That this authority to take part in the performance of public function or to perform public duties must be by direct provision of the law or by popular election. So included na sa mga mayor, mga konsihal, mga senators, mga vice president, mga congressman, governors, mga board members, yun, barangay captains, mga barangay councilors, yun, they are all being elected, no? By appointment by competent authority, kanang mga empleyado, Secretary of Justice, Secretary of Education, gina-appoint na sila, Secretary of National Defense. One appointed as laborer in the government is not a public officer. That a government laborer is not a public officer may be inferred from the rulings of the Supreme Court. So just in this case, no, in this distinction, laborer is not a public officer. So take note of that. But all throughout, we have defined public officer as in any rank. But then, in this particular case of Manigo versus People and People versus Paloma, laborer is not anymore considered as public officer. So take note of public officers, at least na-define na nato unsa ning public officers. So what are those provisions of the law that penalizes the malfeasance and misfeasance in office? We will be defining malfeasance and misfeasance in a while, no? What are the crimes classified under malfeasance and misfeasance in office? The crimes classified under malfeasance and misfeasance in office are: 1. Knowingly rendering unjust judgment. This is particularly true for judges. Second, rendering judgment through negligence. Again, for judges. 3. Rendering unjust interlocutory order. Again, for judges. 4. Malicious delay in the administration of justice. Can comprise of several personnel na ranging from the lawyers up to the judge. Malicious delay in the administration of justice. 5. Dereliction of duty in prosecution of offenses. Well, this pertains to the prosecutors, no? 6. Betrayal of trust by an attorney or solicitor, revelation of secret. Now, this is belonging to private mga practitioners. So, any attorney or solicitor. And another one is direct bribery. And number 8 is indirect bribery. So, number 1, 2, 3, and 4 are misfeasance in the office that a judge can commit. 2, 3, and 4. Judge siya, judge na din pati ang 4, no? And then number 7 and 8 are malfeasance in office that a public officer can commit. Number 5 is nonfeasance. Number 5 is nonfeasance, dereliction of duty in prosecution of offenses. So what is misfeasance? Defined as the improper performance of some act which might lawfully be done. Malfeasance is defined as the performance of some act which ought not to be done. So take note of the difference, ha? And what about nonfeasance? Nonfeasance is the omission of some act which ought to be performed. Crimes under the dereliction of duty, they are those defined from Articles 204 to 209. Mention na 204 to 209, 204 to 209. From 1 to 60 siya, dereliction of duty na siya. The other one, 210 of 211, they are direct bribery and indirect bribery. Now let's go to the discussion of each of those provisions of the law. Dereliction of duty, Section 1. Article 204, knowingly rendering unjust judgment. Any judge who shall knowingly render unjust judgment in any case submitted to him for decision shall be punished by prison mayor and perpetual absolute disqualification. But seldom lang kayo siya mahitabo, no? Kay well, who would file a case against the judge? Because if any, now instead of filing a case against the judge, you just have to appeal your decision. I-appeal mo ang decision dito sa higher court, sa higher up. But or kanimang god ang element of knowingly rendering unjust judgment. It's not a judgment call, but it is the judge having known that it is not a correct judgment, he judged accordingly, nonetheless, no? Isa pa judgment niya, dili correct, kabalo siya na, but then again, he go through with it. Muna ang sabot sa Article 204. Unlike most of the cases, kasi kung if you judge a case, parang you are the one deciding whether or not your decision is correct or not, diba? So, you decide in favor of the other, it will be against the other party. Decide for the other party, it will be against the other party. So, you weigh the evidences, and after weighing it, you make a judgment call. That's it, no? Make a judgment call, and so you will not be liable for it because you know you are just doing your work there. But this one is different, no? Article 204, that the judge know that whatever the judgment that he will be giving is really unjust, that he knows about it, and yet he goes on with it, releasing the judgment. That is the essence of Article 204. Okay, the elements that the offender is a judge, that he renders judgment in the case submitted to him for decision, that the judgment is unjust, that the judge knows that his judgment is unjust. So judgment is defined as the final consideration and determination of a court of competent jurisdiction upon the matter submitted to it in an action or proceeding. Unjust judgment is one which is contrary to law or is not supported by the evidence or both. When rendered knowingly, an unjust judgment is rendered knowingly when it is made deliberately and maliciously. Knowingly means conscientiously, consciously, intelligently, willfully, or intentionally. So despite the after effect, it may be unjust. He releases the judgment without consideration of whoever will get hurt. No? Wala amot pasabot sa 204, knowingly unjust judgment. The source of unjust judgment may either be error or ill will or revenge or bribery. Wala siya. Error, kani, pwede pa rin siya makorek kay error. O, totong judgment call, gani, ill will, kanina naging siya kahigwaos. Revenge, panimalos. Bribery, well, he could get paid, no? Uwit, no? Nabayaran siguro siya. That is why there's unjust judgment and the judge knows about it. So there's bad faith and that there must be evidence that the judgment is unjust. It cannot be presumed. So that if you allege that the judge has rendered judgment which is unjust, you have to prove it. No? You have to show circumstances tending to prove that really that the judge rendered an unjust judgment, and he knows it. It must be contrary to law and not supported by evidence. It does not apply to members of collegiate court. So, may collegiate court, okay. There is a municipal trial court, isa lang ang judge sa isang korte. One sala, one judge. Pag-abot mo sa regional trial court, matugya po, no? One sala, one judge. Yan. Singly, one judge na siya. Pero pag mag-appeal ka na, gikan sa regional trial court to the Court of Appeals, the case will not be decided by one person alone there, no? Just like dito sa Supreme Court, it will not be decided by one person alone. It has to be decided by a collegiate whole. May mga colleagues siya dito collegiate. Like in the Court of Appeals, in every division there are at least 3 justices that will decide a certain case brought before it. Nasa Court of Appeals, ha? Pag-abot sa Supreme Court, at least isa ka-division ay 5 justices dito ang mo decide. If I'm not mistaken, 5 or 3 lang yapon siguro. Yun, collegiate ang tawag nila. And then as a whole, if they render judgment as a whole, en banc ang tawag, en banc, the more it is called collegiate, no? Okay. Judgment rendered through negligence. Any judge who by reason of inexcusable negligence or ignorance shall render a manifestly unjust judgment in any case submitted to him for decision shall be punished by arresto mayor and temporary special disqualification. So, careful kayo ang judge, no? Dapat mo render siya judgment na walay negligence good, no? That the offender is a judge that he renders a judgment in a case submitted to him for decision that the judgment is manifestly unjust, that it is due to his inexcusable negligence or ignorance. But this is very hard to prove. No? When you allege negligence or ignorance on the part of the judge, you really have to prove your case very, very diligently. Kasi mahirap i-prove itong negligence, no? Inexcusable negligence. Lalo na inexcusable. Negligence, it can be apparent, pwede matingnan. But inexcusable, meaning wala sila pa siyang ginawa. Talagang, tawag dito, talagang kapabayaan na talaga ang ginagawa niya. Inexcusable na siya. What is manifestly unjust judgment? It is manifestly unjust judgment contrary to law. It is so manifestly contrary to law that even a person having a meager knowledge of the law cannot doubt the injustice. Abuse of discretion or mere error of judgment not punishable. Error of judgment na judgment call. Unjust interlocutory order. To, iba yung final judgment, ha? While the case is ongoing and all the parties have to present their evidences, no? The moment all evidences has been presented, nag-gather na sa complainant, nag-gather na evidences sa defendant, or in the case of a criminal case, nag-gather na ang evidences sa prosecution, and then nag-gather na po ng evidences sa accused, sa defense, no? After which, the judge will weigh it. That's when he will decide now, and the decision would become a final judgment, no? His judgment. Muna ang judgment. So, moto ang mga, ika sa 204 to 205, moto ang gina-mention, judgment, no? Judgment to negligence, judgment to knowingly unjust judgment, Pag-abot rin sa 206, dili siya judgment because while the case is ongoing, wala pa na human magpapresent ng ebidensya ang mga prosecutor at defense, there could be motions, no? motions that would be filed by party for correction of procedure or something like to assert the rights of the party in that particular case. Nag-file niya yan sa judge, and the judge, and then may mga counter objection pa yan sila, no? Motion, dapat mag-file ka rin ng objection. And the judge, after seeing the motion, will have to decide on it. Note that the evidences are not yet been through being offered. Wala pa ebidensya. Napalamtas, ongoing pa lang ang pag-present sa ebidensya. But here is a motion that needs to be addressed by the judge, and whenever the judge will decide whether or not to grant the motion, that particular decision or order granting or denying the motion is called interlocutory order, no? Interlocutory order. No, ang tawag ha, wala pa ta sa judgment, diri pa ta sa ongoing pa ang kaso. Interlocutory order ang tawag ana. I hope you get me ha. So unjust interlocutory order, any judge so shall knowingly render an unjust interlocutory order or decree shall suffer the penalty of arresto mayor in its minimum period and suspension, but if he shall have acted by reason of inexcusable negligence or ignorance, and the interlocutory order or decree be manifestly unjust, the penalty shall be suspension. So here are the elements. The offender is a judge that he performs any of the following acts: knowingly renders unjust interlocutory order or decree, or renders a manifestly unjust interlocutory order or decree to inexcusable negligence or ignorance. So here it is. What is interlocutory order? It is defined as an order which is caused by the court between the commencement and the end of a suit or action, and which decides some point or matter, but which however is not a final decision of the matter in issue. So wala pa na ang final decision ani, no? The test in determining whether an order or judgment is interlocutory or final is, does it leave something to be done in the trial court with respect to the merits of the case? If it does, it is interlocutory. If it does not, it is final. So, yun yung salient point doon. Yun yung basis, no? To decide whether the order is interlocutory or it is final order. Example, an order granting preliminary injunction or an order appointing a receiver is an interlocutory order. So take note of that ha, in the proseso sa judge ni sa sala. Right. Article 207, malicious delay in the administration of justice. Judge lang yapon delay niya. The penalty of prison correctional in its minimum period shall be imposed upon any judge guilty of malicious delay in the administration of justice. Elements that the offender is a judge, that there is a proceeding in his court, that he delays the administration of justice, that the delay is malicious, that is, the delay is caused by the judge with deliberate intent to inflict damage on either party in the case. So, ito siya, tinuyuan yun na, no? Mere delay without malice is not a felony under this article. So, again, it boils down to the question whether the judge rendered judgment on a judgment call, or did he intentionally render judgment, delay it, did he intentionally delay rendering judgment of that particular case? Article 208, prosecution of offenses, negligence and tolerance. The penalty of prison correctional in its minimum period and suspension shall be imposed upon any public officers or officer of the law who in the dereliction of the duties of his office shall maliciously refrain from instituting prosecution for the punishment of violators of the law, or shall tolerate the commission of offenses. Sa unang panahon, ang nag-prosecute sa mga kaso is ang mayor. Aron na mga prosecutor naman muna, ginaliligate na sila. Now, the title of the article uses the word negligence, which should not be understood merely as lack of foresight or skill. The word negligence simply means neglect of duties of his office by maliciously failing to move the prosecution and punishment of the delinquent. Who can be offenders in Article 208? The offender under 208 is either public officer or an officer of the law. Officer of the law includes all those who by reason of position held by them are duty-bound to cause the prosecution and punishment of the offenders. Sa mga police, siya investigator niya. imong ang investigate nimo gipinding ano yung investigation na kay findings pero imong gitagawa na imong findings sa imong drawer wala nimo gipagawas. Ayan. Yan, you are delaying or negligent ka sa pag-file nimo sa kaso, no? The term public officer extends to officers of the prosecution department whose duty is to institute criminal proceedings for felonies upon being informed of their perpetration. Okay, there must be a duty on the part of a public officer to prosecute or to move the prosecution of offender. Does the following have such duty? Chief of Police, Barrio Lieutenant, a Chief of Police who in breach of official duty failed to prosecute a witting collector in that he failed to file the corresponding criminal action against the latter who was caught possessing witting lists was held liable under Article 208. A Barrio Lieutenant, now Barrio Captain, who in neglect of his duty fails to move the prosecution of and punishment for a crime of arson of which he is informed would, in case the alleged crime was afterwards duly proven, be guilty of prevarication. We will know what is prevarication in a long while, no? Short while. Thus, a fiscal who, knowing that the evidence against the accused is more than sufficient to secure his conviction in court, drops the case, is liable and may be punishable under Article 208. But a fiscal or the city attorney as prosecuting officer is under no compulsion to file the corresponding information based upon a complaint where he is not convinced that the evidence gathered or presented would warrant the filing of an action in court. Of course, the power of the city attorney or prosecuting fiscal in connection with the filing and prosecution of criminal charges in our court is not altogether absolute, but the remedy is the filing with the proper authorities or court of criminal or administrative charges if the alleged offended parties believe that the former maliciously refrained from instituting actions for the punishments of violators of the law. So yun, no? Piskal ni siya, piskal, no? Sagaran ng mga piskal, pag mag-file o ka ng complaint niya sa sulod sa prosecutor's office, they are mandated to decide whether or not there is probable cause, and if there is probable cause, to file the case before the court within 60 days from filing of the last last pleadings. Kasi dito sa fiscal's office, pwede man mag-file of pleadings dito, no? May affidavit complaint, tumago na sa respondent, file po sila counter affidavit. And then after all the counter affidavit and affidavit complaint and counter affidavit has been filed, including the answers to counter affidavit, reply, and rejoinder of the reply. Pagtapos na tayo nakafile ito, the prosecution office has until 60 days to decide whether there is probable cause to warrant the filing of the case in court. Wala siya diya sa fiscal, no? Okay, maliciously signifies deliberate evil intent. The offender must act with malice. Tinuyuan yun basta na yung malice, iya ganun siyang ihuna-huna, and then tuyo niya. Thus, municipal president who held cockfights on the days not authorized by law to raise funds for the construction of a ward in the provincial hospital was not liable under 208, for the word maliciously means that the action complained of must be the result of the deliberate evil intent and does not cover a mere voluntary act. The accused was convicted only of illegal cockfighting. A dereliction of duty caused by poor judgment or honest mistake is not punishable. Let's go to Article 209, betrayal of public trust by attorney or solicitor. Solicitor, maaaring siya ang attorney, another class of attorney, pero wala yan din sa kwan. Another is solicitor general. Ma-hire din siya ng mga attorney na sa gobyerno under the solicitor general's office. Kabalo mo sa nakaila mo sa pinaka-known nga solicitor general karon, kato nag-file og kaso sa si Kalida. Ikantapa na siya karon, taga Davao ba yan, taga Davao del Norte. Si Jose Calida ang Solicitor General karong panahon na. Anda na po siya order nga asan siya letter sa Red Cross nga ipa-audit si Gordon sa iyang pagka-head sa Red Cross. Pila na ang kwan. Pila na siya katuig sa Red Cross, wala gyapon siya awa-awa. Anyway, so let's proceed, no? In addition to proper administrative action, the penalty of prison correctional in its minimum period or a fine ranging from 200 to 1,000 pesos or both shall be imposed upon any attorney at law or solicitor, procurador, judicial, who, by any malicious breach of professional duty or of inexcusable negligence or ignorance shall prejudice his client or reveal any of the secrets of the latter learned by him in his professional capacity. So, pag professional na ganyan mo, lawyer na mo, in the future, no? Mga ginang tenet sa lawyer. Once na there is somebody who will trust you and become your client, and entrusted to you the secret of the client, including what he did wrong, no? Whether nakakommit siya criminal act or not, you should not reveal this particular secret of your client to anybody. No? The moment you do that, you will be subjected to disbarment. The same penalty shall be imposed upon, aside from these particular charges na ipataw sa imo Article 209, no? The same penalty shall be imposed upon any attorney at law or solicitor who, having undertaken the defense of a client or having received confidential information from said client in a case, shall undertake the defense of the opposing party in the same case without the consent of his first client. Usually, na yung mga inaani, no? Karang initially, ikaw nag-defense sa yaha, and then later on, hawa na kasaya pagka-client niya sa imo, hawa. No? And then, the other party, kalaban sa imong client, yato sa imo para mapadepensa, inyong may gidawat, kalaban niya itong client ni mo dati, dili na siya pwede you should ask first the consent of your previous client whether he will allow you to be an attorney of the person enemy, who is the enemy of your client, no? Kung i-allow ka niya mahimo ka attorney sa enemy sa imong client, then that's good. But if not, ayaw na lang yun, no? Kami, pag naana mahita mo, wala yun. Bisang pag pila kadako ang kwarta ibayad sa mga diligyon nimo. But ang uban, sikreto siguro uban, basta na kwarta man good, mauna ang problema, basta kwartahan na. Anyway, acts punished as betrayal of trust by attorney by causing damage to his client, either by malicious breach of professional duty, by inexcusable negligence or ignorance, by revealing any of the secret of his client learned by him in his professional capacity, and then by undertaking the defense of the opposing party in the same case without the consent of his first client. After having undertaken the defense of first client, or after having received confidential information from said client. So there is no solicitor or procurador judicial under the rules of court. It is procurador judicial or solicitor is a person who had some practical knowledge of law and procedure, but not a lawyer, and was permitted to represent the party in a case before an inferior court. So lahat na yung solicitor na ginamention dili. Dili siya lawyer, pero knowledgeable siya as a lawyer, no? Kabalo siya sa mga rules of court procedure, no? So under the rules of court, in the court of a justice of peace, a party may conduct his litigation in person with the aid of an agent or friend, or with the aid of an attorney. Direct bribery. That is the direct bribery, So, samayin nyo ang isip ano yung bribery. Of course, suhol, no? There are situations. Kung naka-follow up dito sa gobyerno, and then, na mga situations na dugay kayo mo process, and you will want it to be fast track, all you have to do is pay the corresponding officer na process ani. Under siya ang table. Bayaran mo siya. Gawas na yung papel. Bribery. Kung dawaton niya, bribery yung kaya na. Sigara ako na lunggan sa customs, dili mo gawas yung papel, dili mo gawas sa mga items, mga container dito sa customs yard kung dili ka magbigay. Open ang mga drawer sa mga customs, hatag na nimo, and then daga na yung papel. Kada signatory nga involved. Pag ato na siya papel, lain po kay ihulog dito sa iyang drawer. Inana katalamak, I don't know karon pero that's how they do it in customs daw nila. Anyway, let's read Article 210. Direct bribery. Any public officer who shall agree to perform an act constituting a crime in connection with the performance of his official duties in consideration of any offer, promise, gift, or present received by such officer personally or through the mediation of another shall suffer the penalty of prisión mayor in its medium and maximum periods, and a fine of not less than 3 times the value of the gift, in addition to the penalty corresponding to the crime agreed upon if the same shall have been committed. If the gift was accepted by the officer in consideration of the execution of an act which does not constitute a crime, and the officer executed said act, he shall suffer the same penalty provided in the preceding paragraph. And if said act shall not have been accomplished, the officer shall suffer the penalties of prison correctional in its medium period, and a fine of not less than twice the value of such gift. If the object for which the gift was received or promised was to make the public officer refrain from doing something which it was his official duty to do, he shall suffer the penalties of prison correctional in its maximum period, to prison major in its minimum period, and a fine of not less than 3 times the value of such gift. In addition to the penalties provided in the preceding paragraphs, the culprit shall suffer the penalty of special temporary disqualification. The provisions contained in the preceding paragraphs shall be made applicable to assessors, arbitrators, appraisal, and claim commissioners, experts, or any other person performing public duties. So, there you are, bribery. Direct bribery. Bayaran mo, makitaan ka. Yan, direct bribery. Now, take note that the person punished here, the person accountable here is any public officer, okay, who shall agree to perform an act or will not perform an act provided na siya consideration, na gift, na promise, na offer. O na ang gift, promise, offer. So, kung trabahoon ni mo, dapat trabahoon, dili ni mo trabahoon. Kung dili dapat trabahoon, imong gitrabaho. Kung dili dapat, no? So, na ang malfeasance o misfeasance diya. Anyway, but take note, as I was stressing a while ago, that only public officer is punished here. But, kabalo mo sa saying, anang principles na saying, ang saying yung ginaingon, paminaw mo sa saying takes two to tango. O, kabalo mo pabila mo na nga saying, di ba? It takes two to tango. So that, sa may pasabot na ko anybody can explain in relation to what we have discussed? It takes two to tango. Any reaction? In reaction to the sayings, it takes two to tango in relation to what we have discussed so far. Sige daw. Sa mga reactions ninyo, it takes two to tango. Kung magsayaw ka, duha man gimuha na, di ba? Sayaw, tango. Di ba pwede, dili pwede isa lang magtango, ikaw lang isa. Tango ka ni. Tango. It takes two to tango. Ayan, di ba? Yung mga tataan So, any reaction in regards, in connection with what we have discussed so far? It takes two to tango. What can you say about that? Kaysa mga parties, who are you talking about? It takes two to tango. Oh, what about you, Joanna Lynn, Tivis? You have reaction? Okay. So, example daw, Joanna Lynn. Right? Another example. Any other? Give chance to others. Ay, interesting ni siya. It takes two to tango. And connect it with what we have just discussed a while ago. Ako ang ginaingon, it takes two to tango. I-narrate na siya sa atong discussion karon. Example. Isang specific example. Give me a specific example. Actually, you are correct, Tristan Arista. That's what. In the crime of bribery, there's no bribery if there's only one of you. How can an public official commit bribery? It's because there is a private person that bribes the public official. Mana siya. So, dili makommit ang bribery ng public official kung walay private person na naghatag sa iyang bribe. So, that's why in this kind of crimes, it takes two to tango. This takes two to tango. As punishable in direct bribery, a public officer commits direct bribery by agreeing to perform. Asa siya na-agree? To perform or by performing in consideration of any offer, promise, gift, or present. Kisa may naghatag aning offer, kisa may naghatag aning promise, kisa naghatag aning gift o present. It's an act of constituting a crime in connection with the performance of his official duties. By accepting a gift in consideration of the execution of an act which does not constitute a crime in connection with the performance of his official duty. Take note, you mentioned with the performance of his official duty. By agreeing to refrain or by refraining from doing something which it is his official duty to do in consideration of gift or promise. So yun yung mga elemento doon, no? Take note of these elements of direct bribery. If we say direct bribery, napot na indirect bribery, ha? What is then indirect bribery? Let's say to another article, indirect bribery. Just take charge of the element there, no? Saka na yung mga elements of bribery in direct bribery. But before that, direct bribery is a crime involving moral turpitude. Kanima kung crime involving moral turpitude, na gini malis ani, no? But higher ni siya nga level sa crime, so that kung commit ka ani, even the lawyer committing this crime can be disbarred because he commits a crime involving moral turpitude. So bantay-bantay mo ani mga professionals, so mga commit ka crime involving moral turpitude, even if it's not bribery, there are other crimes that is considered as belonging to moral turpitude, involving moral turpitude, one of which is bribery. So moral turpitude can be referred upon from the third element, the fact that the offender agrees to accept a promise or gift and deliberately commits an unjust act or refrains from performing an official duty in exchange for some favors, denotes a malicious intent on the part of the offender to renege on the duties which he owes his fellow men and society in general. Also, the fact that the offender takes advantage of his office and position is a betrayal of the trust reposed on him by the public. It is a conduct clearly contrary to the accepted rules of right and duty, justice, honesty, and good morals. In all respects, direct bribery is a crime involving moral turpitude. Take note of that, ha? Now let's go to indirect bribery. The penalties of prison correctional in its medium and maximum periods, okay? Suspension and public censure shall be imposed upon any public officer who shall accept gifts offered to him by reason of his office. Elements that the offender is a public officer, that he accepts gifts, that the said gifts are offered to him by reason of his office. Not necessarily letting you do an act or not doing an act. Basta ihatag lang siya gift sa imong gidawat. That's indirect bribery na. You don't have to do anything. You don't have to be told that you should do something or be told that you should not do something. Basta lang naghatag siya gift sa imuha and then you accept it. Ang isa pinaka-element is that you are a public officer. So, yun yung problema. So, indirect bribery ang labas ni Mudira. Take note of the distinction, while indirect bribery, nagay ipabuhat sa imuha, or kung nakaibuhaton, nagay dili ipabuhat sa imuha. So, with the consideration siya, na exchange, na promise, na gift, na mga money involved, no? Good. Kanang pang-konsuelo, good. Kaya di man ko na malikayan ko ng nagay muhatag sa imuha. No? Mamugos na dawaton, madawat yun siya. But, kanang iingon ni Duterte, murag kanang kind of play of words ng gani, dawatan yun kay napugos man. But if we are to be strict about it, dili siya pwede. Dili siya pwede, no? Presidente ng istorya, hindi mo ginamakon sa imuha. Although, strictly, dili ka pwede, but secretly, pwede God kung mamugos na yun sa imuha. Well, what can you do? Ipugos na sa imuha ihatag mo na sa imuha. Hindi mo dawaton. As long as wala na kita ang gidawat ni mo, kana lang. Wala ang konsuelo ni Mudira. But then, as I said, play of words to kay President Duterte. Thank you for bringing this up. Lalo pakatang si President Duterte, mayor pa lang siya. Magsige na iyon siya sa mga sakop, pakapitan. Kung na yung muhata sa iyo, tawata. Ayaw yun mo pangayo. Ayaw na yun mo pangayo. Tapos buhata lang yung trabaho niya. Tapos, well, na mo appreciate na muhatag sa inyo, dawata, basta kinakasing-kasing. Basta nag-iwan na ka nga, di ka mo dawat, tapos ipamugos yun mo, dawata na lang, wala kay mahimo, ana. But then again, if we really be strict about it, indirect bribery yun ang tawag, ana. But ang pangutana, kinsa mo complain sa imo, kinsa mo complain against you when you are accepting these gifts na walay nakakita, and then gipamugos o pahatag sa imo. Kinsa may mo complain mo na ang problema dira. Kay the person who would complain against you could be your enemy. Wala na lagot kay sa imuha. But then again, naghimo lang ka sa imuhang trabaho, wala may mo complain siguro. Well, good faith na sa imuha. kataon lang ang gitagaan ka, wa kay mahimo, wala mo gidawat tapos di pamugos. Ang uban iuli mo na, uban uli pa uban basta laman ba lang gidawat. It remains to be a secret. But again, ayaw niya ikwantong take into serious consideration tong ingon ni President Duterte. As I said, play of words lang to niya para pang lang sa mga tao kay di man gina malikayan nga namang gimuhatag labi na kanang salamat na siya appreciate yung mayon sa yung ginabuhat nimo niya mahatag siya. Well, there's a way to do it, no? Instead ni hatag nimo sa individual, ihatag sa office and for everybody to share. Padala kang ice cream dito. Sorry mo man ang ginabuhat doon sa korte, padalag ice cream, padalag dito so nito. But for all the others na dili na it's not bribery. Para na sa ilang celebration, whatever, sa ilang kalipayon dito. That's how to do it. Pero kung imon siya ihatag sa individual jud, alay na ng istorya. Oh, kaya na istorya na. Okay, clear? Baljim pakatang, individual give pagkaon basta lagi. Ang batayan na nimo, bawal jud na siya. Pero kung ipamugos jud, walay nakakita. Walay makita, makita nimo wala kayo dawat. Ana, pero I'm not encouraging that. And butang lang sa inyo una-una, bawal jud na. Anything ay hatag sa imo because ang reason kay public officer ka, bawal jud na. Yes, Graham? All problema basta for all. Basta for all. Dili lang sa specific persons. For all na siya. And then makita ang appreciation, dili ba na siya kabalibaran? Oh? For sa specific person na ihatag, iyaharan na, ay na po, iyahalang na apa na, dili na pwede. Bawal jud. Anything. Basta ang purpose ka because you are a public officer. Anything. Huwag na ibutang sa inyong alipatakan despite whatever President Duterte has told you. Bawal jud. So, careful lang sa imong reputation, careful lang sa pagservisyo. Wala may mawala sa tuwa kung mo tamod taana, no? Kay wag na. Di man na makamatay, no? And then dili mo po na makapobre sa ibuha kung dili mo dawakot. Basta, careful ka lang. Again, the law is very strict about it. If you were very strict about it, even accepting gift, no? Public officer should not accept any gift offered to him because such gift is offered in anticipation of future favor from him. Such gift received now will in the future corrupt him or make him omit the performance of his official duty. One ang pandre, rationally ana. Gift is usually given to the public officer in anticipation of future favor from the public officer. So, a veterinarian of the Board of Health entrusted with the duty of examining mules which were offered for sale to the government received a certain amount of money from the vendor of mules after the latter had received from the government the purchase price of the mules sold. There was no evidence to the effect that the money was given for the purpose of preventing the veterinarian from doing or inducing him to do something pertaining to his officer. Okay, he accepted the gift offered to him by reason of his office. And this is actually an indirect bribery. Will there be indirect bribery if a public officer accepts a promise of gifts made to him by reason of his office? Article 211 does not use the word promise but the phrase shall accept gifts. So the essential ingredient of direct bribery as defined in Article 211 of the revised penal code is that the public officer concerned must have accepted the gift for material consideration. There must be a clear intention on the part of the public officer to take the gift so offered and consider the same as his own property from then on, such as putting away the gift for safekeeping or pocketing the same. Mere physical receipt unaccompanied by any other sign, circumstance, or act to show such acceptance is not sufficient to lead the court to conclude that a crime of indirect bribery has been committed. To hold otherwise will encourage unscrupulous individuals to frame up public officers by simply putting within their physical custody some gift, money, or other property. So there is no attempted or frustrated indirect bribery. Indirect bribery has no attempted or frustrated. Consummated din siya, no? Because it is committed by accepting gifts offered to the public officer by reason of his office. If he does not accept the gifts, he does not commit the crime. If he accepts the gifts, it is consummated. Qualified bribery, kani. If the public officer is entrusted, kaning yung qualified, the penalty here is higher than ordinary bribery. Take note of that, ha? Qualified na siya eh. Ano siya graduation, no? Right? Most severe din niya kain ng bribery. If any public officer is entrusted with law enforcement and he refrains from arresting or prosecuting an offender who has committed a crime punishable by reclusion perpetua or death, in consideration of any offer, promise, gift, or present, he shall suffer the penalty for the offense which was not prosecuted. Yawa, oy. Siya pa yung suffer sa penalty sa office, no? If it is the public officer who asks or demands such gift or present, he shall suffer the penalty of death. Siya pa mismo ang nag-demand, no? That's the qualified bribery for you. No? Kung unsang penalty sa katong tao nga wala na prosecute, reclusion perpetua, mauna ang imuang masuffer, reclusion perpetua. Kung ikaw mismo nag-demand sa kwarta, and then you will suffer death. Kaya lang wala na may death penalty ko karon, no? Article 212, corruption of public officials. The same penalties imposed upon the officer corrupted, except those of disqualification and suspension, shall be imposed upon any person who shall have made the offers or promises or given the gifts or present as described in the preceding articles. So here is no, katong private official, private person na naghatag sa gifts. Mo na ni ang ilahang penalty. So as I said, it takes two to tango. Ang katong gibayaran nimo, katong gi-bribe, mag-penalize. Ang katong nag-bribe, mag-penalize po. The same penalty, no, upon the officer corrupted except those disqualification and suspension. So kaya dili man sila officer, wala man sila sa gobyerno, wala na ilahang disqualification and suspension. Pero ang katong officer na mag-suffer ang disqualification and suspension. Pero kung in terms of penalty o sa imprisonment, kung reclusion temporal, prison mayor, reclusion perpetua, o mo na ilang penalty sa katong public official, ang katong naghatag sa bribe, maupod to ang iyang penalty. Okay? Take note of that, ha? Again, it takes two to tango. The offender makes offers or promises or gives gifts or presents to the public officer. That the offers or promises are made or the gifts or presents given to the public officer under circumstances that will make the officer liable for direct bribery or indirect bribery. Presidential Decree number 749, approved on July 18, 1975, which grants immunity from prosecution to givers of bribes and other gifts to their accomplices in bribery and other grave cases against public officers, provides. So, naikuha na, katong mga whistleblower, ikaw naghatag bribe, tapos a public officer, ma-prosecute to siya, ikaw naghatag information na nag-bribe ka, pwede ka ma-exempt from prosecution, you will be granted immunity under Presidential Decree number 749, no? You will be called whistleblower here. Anti-graft and Corrupt Practices Act, Republic Act 3019 as amended by Republic Act 3047, PD 77 at BP bilang 195. So these are the most filed cases involving prosecution of public officers or employees under this particular law, Republic Act 3019. Kasagaran sa gipang file ito sa Ombudsman, maabot na sa Sandigan Bayan, sa Regional Trial Court, dire ginakuha ang mga kaso nila. Okay? Anti-graft and Corrupt Practices Law. It is a policy of the Philippine government in line with the principle that a public office is a public trust to repress certain acts of public officers and private persons alike which constitute graft and corrupt practices or which may lead thereto. So, take note, ha? Definition of terms here, ha? Government includes the national government of the Philippines. Local government, the government-owned or government-controlled corporations and all other instrumentalities or agencies of the public of the Philippines and their branches. Public officer includes elective and appointed officials and employees, permanent or temporary, whether in the classified or unclassified or exemption service receiving compensation or even nominal from the government as defined in the subparagraph. Receiving any gifts includes the act of accepting directly and indirectly a gift from a person other than member of the public officer's immediate family. Person includes natural and juridical persons unless the context indicates otherwise. Natural persons, physically person na siya. Juridical persons could be corporation, partnership, and other cooperatives, union occupations. Wala siya natural or juridical persons. Corrupt practices of public officers. Well, just read this one. As I said, this particular law is the reason why there are so many cases involving public officials in the government. Kani nga balaod ang ginahiman. Kani, under this law, it shall be unlawful for any person having family or close personal relation with any public official to capitalize or exploit or take advantage of such family or close personal relation by directly or indirectly requesting or receiving any present, gift, or material or pecuniary advantage from any other person having some business, transaction, application, request, or contract with the government in which such public official has to intervene. Family relations shall include the spouse or relative by consanguinity or affinity in the third civil degree. The word close personal relations shall include close personal friendship, social and fraternal connections, and professional employment, all giving rise to intimacy which assures free access to such public officer. Take note, encompassing na siya. Kung na public officer dito, tanan niyang mga amigo, igsuon, mga silingan, mga close ties, kato sila nanawat og gifts because sa laing tao, indirectly sa yahan tato, pero sila nagdawat mo ni para ma-influence niya ang decision sa public officer na naghimo sa mga dokumento, whatever, doing his job, masway ang iyang decision making power dito sa sulod because it is being influenced by the close family ties. Take note, include rin family relations shall include spouse or relative by consanguinity or affinity. Ang close personal relations also include personal friendship, social and fraternal. Paternity, pwede po niyo. Fraternal connections and professional employment. Ay, kada mga kagrupo ni mo sa profession, sa CPA, mga kagrupo dira. All giving rise to intimacy which assures free access to such public officer. Grabe kayo encompassing ni nga balaod ni. Yeah, just read this one. Prescription of offenses. Sa man yung prescription of offenses? Karon gihimo ang offense, how many years na pwede within that year pwede ka makafile og kaso against sa iyaha? According to Section 11 of that law, Anti-Graft and Corrupt Practices Act, prescription offenses, all offenses punishable under this act shall prescribe in 15 years. So after 15 years, niya gusto ko file og kaso against atong tawahan or whatever, under the Anti-Graft and Corrupt Practices Act, dili na siya pwede ma-entertain, no? Nag-lapse na ang kaso. Prescribed na ang offense. Okay? Kani ang grabe, no? Section 12, termination of office. No public officer shall be allowed to resign or retire pending an investigation, criminal or administrative, or pending a prosecution against him or for any offense under this act or under the provisions of the revised penal code on bribery. So until wala pa mahuman ang kaso nimo na pending pa, dili ka pwede maka-retire, dili ka pwede maka-resign sa imong opisina. Okay, Republic Act 1379, i-forfeit ang mga property nga sa nakuha gikan sa tao naka-violate sa anti-graft law anti-graft law, no? I-forfeit ang property nga makuha ang tawhana. Property to have been unlawfully acquired by public officer or employee. And may forfeiture proceedings na. May hearing, may petition, and then hearing pa, and then they have to prove that really that particular properties belong to the person out of the bribery acts that he committed when he was still in office. Frauds and illegal exactions and transactions. For na ta. Okay. Article 213, frauds against the public treasury and similar offenses. The penalty of prison correctional in its medium period to prison mayor in its minimum period, or a fine ranging from 200 to 10,000 pesos or both shall be imposed upon any public officer who, in his official capacity, in dealing with any person with regard to furnishing supplies, the making of contracts, or the adjustment or settlement of accounts relating to public property or funds, shall enter into an agreement with any interested party or speculator, or make use of any other scheme to defraud the government. Being entrusted with the collection of taxes, licenses, fees, and other imposts, shall be guilty of any of the following acts or omissions: demanding directly or indirectly the payment of sums different from or larger than those authorized by law; failing voluntarily to issue a receipt as provided by law for any sum of money collected by him officially; collecting or receiving indirectly, directly, by way of payment or otherwise things or objects of a nature different from that provided by law; When the culprit is an officer or employee of the Bureau of Internal Revenue or the Bureau of Customs, the provisions of the Administrative Code shall be applied. Yun ang frauds, no? Other frauds, in addition to the penalties prescribed in the provisions of Chapter 6, Title 10, Book 2 of this Code, the penalty of temporary special disqualification in its maximum period to perpetual special disqualification shall be imposed upon any public officer who, taking advantage of his official position, shall commit any of the frauds or deceits enumerated in said provisions. The mga elements are that the offender is a public officer, that he takes advantage of his official position, that he commits any of the frauds or deceits enumerated in Articles 315 to 318. Sa mga special disqualifications, sa mga punishment ni temporary special disqualifications. It is maximum period to perpetual special disqualification. Sa number 2, table of penalties, number 43. Ito na i-research on niya. But this special disqualification is for you not to be allowed to be a government employee again. Dili na ka pwede dawaton any position of the government. Ay depende kung kano sa kutob na perpetual special disqualification, na pwede temporary special disqualification. Ano siya period kung ano sa kutob, no? Na dili ka pwede madawat sa gobyerno. And then perpetual, kaning perpetual forever gani siya, na di na ka pwede madawat sa gobyerno. Special disqualification. Prohibited transactions. The penalty of personal correctional is minimum period or fine ranging from 200 to 1,000 pesos or both shall be imposed upon any appointed public officer who during his incumbency shall directly or indirectly become interested in transaction of exchange or speculation within the territory subject to his jurisdiction. Take note that the official here is an appointed public official. Dili siya elective, ha? That he becomes interested directly or indirectly in any transaction of exchange or speculation. That the transaction takes place within the territory subject to his jurisdiction. Kung sa syudad, dito sa city ra po. Kung sa province, sa entire province na po, no? Sa municipal, dito sa munisipyo ra po siya ang jurisdiction. That he becomes interested in the transaction during his incumbency. Possession of prohibited interest by public officer. The penalty of arresto mayor in its medium period to prison correctional in its minimum period or fine ranging from 200 to 1,000 pesos or both shall be imposed upon a public officer who directly or indirectly shall become interested in any contract or business in which it is his official duty to intervene. Na siya direct participation, na siya direct active participation nga kontrata, and then interesado siya, this will be punishable, no? This provision is applicable to experts, arbitrators, and private accountants who in like manner shall take part in any contract or transaction connected with the estate or property in appraisal, distribution, or adjudication of which they shall have acted unto the guardians and executors with respect to the property belonging to their wards or estate.